Hello and welcome to today's Bloomberg Law webinar. At this time, all lines are in a listen-only mode, and the floor will be open for questions following the presentation. Please submit your substantive questions via the Q&A tab and technical support questions on the Tech Support tab on the right side of your screen. To access the PowerPoint or other files associated with this webinar, please click on the Resources link listed in your upcoming webinars or recent registrations on your dashboard. If you wish to receive credit for this webinar, please make sure to respond to the presence check codes popping up on your screen throughout the webinar. You will need to respond to the majority of these codes in order to receive credit. Please fill out the webinar evaluation survey as well as confirm your certificate information at the end of the webinar. Your certificates will then be emailed to you. If a jurisdiction is pending, you will receive the approved certificate via email as soon as it is available. If you have any questions about continuing education credits, please email us at credits@bna.com. Before introducing the speakers, I would like to thank WSG for sponsoring today's webinar, Cross-Border Technology Deals, M&A Trends, and Challenges. WSG is a globally recognized resource for professionals and their clients to receive the highest quality value and service from legal, investment banking, and accounting services. WSG provides members the ability to create new business opportunities and relationships to better serve their clients. To learn more, visit www.worldservicesgroup.com. I would now like to introduce today's speaker. Christina Agassi serves as the Vice President and Associate General Counsel for Zeta Global, a global data-driven marketing tech firm founded in 2007. In this role, Christina manages and oversees a variety of legal matters, including acquisitions and divestitures, joint ventures, IP, equity, commercial transactions, and other legal issues facing a rapidly growing international company. Stacey Frazier is Global Executive Counsel for Competition Law and Policy at the General Electric Company. Her practice includes responsibilities for transactions, compliance and counseling, and internal investigations. Bernhard Hansel is an attorney at law in the firm's IT/IP and media department and deputy head of Dorda's Digital Industries Group. His practice covers drafting and negotiation of international IT-related contracts, outsourcing, license, franchising, and distribution contracts, as well as IT, IP, and media litigation. Anand Saha is partner based in Clifford Chance's New York office and has been at Clifford Chance since 2001 and a partner since 2012. Anand specializes in international and cross-border transactions and is admitted to practice in both New York and England. I would now like to turn the presentation over to Anand Saha.
Thank you so much, and thank you very much, everybody, for joining this panel on cross-border technology deals, M&A trends, and challenges. In today's session, we're going to focus on the key challenges and trends when advising on cross-border tech deals. We want to leverage our fantastic panel's experience on how to navigate these challenges. Some of the key items we plan to cover today include the effect of tech developments and world events on deal making, ethical and cultural considerations in cross-border tech transactions, finding the right balance between global and local standards, and challenges in collecting and processing data and data privacy. We're going to do our best to move through the topics as quickly and efficiently as we can so that we leave some time for your questions at the end. Before we start, a quick disclaimer. After all, this is a panel full of lawyers. I would like to note that all comments and viewpoints discussed during this panel session are the panelists' own opinions and accordingly not affiliated with their respective companies or law firms. With that, let's get started. So my initial question, we talk about cross-border tech, and I would like to know, what does cross-border tech mean to each of you now? We are, of course, living in a world where almost everything is described as a tech company. Software companies we used to think of as tech, disruptors, new entrants into the market, as well as the more traditional financial institutions and or industrials who now regard themselves as tech companies first and foremost. Stacey, I think GE is one of those companies. So starting with you, if I may, in the context of deal making, what is tech to you and what is cross-border?
Thanks, Anand, and thanks for having me. So I think you're exactly right. How we've talked about tech has changed quite a bit. 10 years ago, when we talked about tech, we talked about the same handful of companies, the Microsofts, Apples, Intels, Google, as well as Silicon Valley startups. But this is an outdated mode of thinking. To take your point, take GE as an example. We're a company with a very industrial legacy. We make turbines, aircraft engines, electrical equipment, light bulbs, but we're now reliant on software and data to effectively service products. So rather than sending an engineer out to the field to repair a machine, for example, GE and many other companies like GE can use digital simulations or troubleshooting to isolate the problem and solve it remotely. Or it can use 3D printing to manufacture a part. So companies like GE are increasingly developing their own platforms to manage data and collecting significant quantities of customer information to help better service that customer. Only often when we're talking about data, we're talking about consumer data, and that's what we see in the headlines right now. Companies like GE or other industrial companies are talking about customer data that's other companies, not consumer. And so when I see a company amassing customer or consumer data or developing platforms to serve their customers, that to me looks like a tech company, even if they are selling airplanes. And as an antitrust lawyer, I think that's an important thing to think about because that's often how the regulators are going to approach it as well. They're going to look at those components. As to the second half of your question, it seems like just like everything is tech these days, every deal seems to be cross-border. I do antitrust law, as I said, and one of our biggest roles in the deal context is determining where we need to file competition law notifications. And that's changed dramatically over the past decade or so. Years ago, a U.S.-based company with a deal of a certain size would be filing in the U.S. and maybe, in the case of an exotic deal, the European Commission. But now it's very rare to have a deal of any significant magnitude that doesn't trigger filings in 5 or 10 or 20 or even more countries. That's in part due to the proliferation in merger control regimes globally, but that's in part due to the more global nature of business that's facilitated by tech companies. Tech companies, and I mean this definition in the broad sense we've started discussing, are able to serve many more companies and many more customers in farther-flung places, so you're seeing deals cast a much larger net because you have customers and revenues coming from everywhere.
Thanks so much, Stacey. That's really helpful. And I just wanted to follow up on some of those themes that you outlined there, and turning over to Christina, because when we talk about cross-border transactions, and as you mentioned there, that seems to be very, very, very many transactions these days, especially in the tech world. The effect of world events can't be understated. So when we talk about cross-border transactions, how do you think companies need to factor in political turmoil, world events? So right now we have the US-China trade war, we have the protests in Hong Kong, over in Europe we have Brexit and other issues. What's your perspective on that?
Thanks, Nanda. I'm happy to be here today. I think it's an excellent question. And I think the first thing we must acknowledge is that no one is immune to these events. Even if you are truly, purely U.S. domestic organization, you will still be impacted if you have clients or vendors abroad, and who doesn't have those now? You will certainly be impacted if you are considering doing a formal, let's say, JV or acquiring a foreign entity or assets. On the other hand, because the world is so interconnected today, your competitors are facing similar, if not exact same obstacles. Therefore, I would say always keep an eye on world events, but those should not stop you from aggressively pursuing international strategy, if that makes sense for your company, given your customer demand, revenue growth goals, and let's say appetite for risk. I'd say go boldly, but make sure you have a viable exit strategy. You might need to use it.
Thanks so much, Christina. So let me follow up on that by going over to Bernhard over in Austria. So Bernhard, what do you think about this? Sitting in Europe, are the events that are the subject of such heightened global attention, including Brexit, which is, I guess, closer to you, and stuff going on in other parts of the world, is that impacting the way that you guys do business and the sort of advice you're giving your clients, or the sort of advice that your clients are seeking from you, particularly as that relates to tech?
Yes, definitely. Brexit is a very good example, as, of course, the UK is a very strong business partner of the other EU countries. It is a tech hub, and particularly when it comes to tech companies, it is often the first or last point where data is distributed because before it goes overseas to the US or somewhere else. And the Brexit has definitely caused a lot of uncertainty, which of course brings chances as well as risks. But many companies also try to take these chances, which is of course a good way. Nevertheless, the uncertainty that it brings is of course something where we as lawyers specialized in IT and in mergers in this respect, can step in and give clients more certainty and give them advice on these points. When it comes to the future, I think it will be very interesting also how the UK will maintain or change their existing legislation, because this will also one way or the other bring new chances or new risks to companies. Another point is that many UK companies may in the future wish to switch to the EU with their head offices, because that may facilitate trading with other EU countries or other EU companies. While we now have not yet seen a very dramatic switch from the UK to the EU, we will see what happens after Brexit has finally started.
Yeah, totally. And just continuing on that, I mean, these events obviously have huge amounts of uncertainty all around them, and they're also highly political. And so going back to Stacey, I'd be really curious to hear, Stacey, your views on how these sorts of high-profile global events that are so covered with politics could have an effect on the merger review process in particular that you work on.
Absolutely, and you're absolutely right that we have to be aware of politics when we start the antitrust review of a given deal. I mean, typically, antitrust review is a well-defined economic-based analysis that should focus on how a particular transaction will impact competition in defined affected markets. Theoretically, that doesn't sound very political, and it should not be a political exercise. But we are concerned about how global events shape antitrust review. With the trade war in China, people are predicting that the antitrust review agency there slows down its review of transactions involving U.S. companies, or imposes remedies that are not based on sound economic principles, or even blocks a deal based on principles other than traditional antitrust analysis. And this is outside the antitrust realm, but similarly, in China, when you're sell side, you have to think really hard about whether your transaction will be subject to CFIUS and foreign investment review here in the United States. So you really have to think about those things when you're doing your deal, because you typically approach it from the basis of what do the antitrust regulators ask for, and we have to wonder, I'm not saying we're seeing evidence of this, but we have to wonder if political considerations are going to enter that. Same thing in Europe. Regulators in Europe have stated that creating national champions is a priority, so we have to wonder if that's going to be reflected in their competition law enforcement. Might an otherwise anti-competitive deal go through because it will help create a national champion, or vice versa? And with Brexit, we're seeing another powerful antitrust regulator, the CMA, start to enter the fray much more forcefully, which creates another level of uncertainty. And finally, I have to say, we're not immune from this here in the United States. Presidential candidates are talking about antitrust. It's part of the political discourse now, and the agencies undeniably are going to respond to that or consider that when they go about their deal review processes.
Yeah, absolutely. I totally agree with that. And I just think in terms of when we talk about these events and these uncertainties, obviously there's an impact on M&A, but I think we should spend a little time talking about capital markets and securities too. I mean, obviously in the tech space, a lot of companies come to the point where M&A deals are happening because they've reached a point through doing securities offerings in the past where they have the capital and the profile to do M&A deals. So looking at the companies who are doing securities offerings, I'd be curious, Christina, to get your view. How does this political turmoil and these sorts of events impact securities offerings? Are you seeing similar uncertainties, issues there?
Oh, absolutely. I would say during the last 20 years, international capital flow has been truly transformed. I think that's directly due to the open border trade policies adopted by EU, US, and other key regions around the world. I know that's changing, but it already had an impact. It really is fascinating to me that New York exchanges are no longer default exchanges even for domestic US companies. US companies can raise significant capital by listing on exchanges outside the US while still saving time and listing expenses associated with New York exchanges. For example, the London and Hong Kong exchanges are legitimate options for a lot of tech companies nowadays. On the other hand, some prominent companies are choosing to list domestically in their local markets, knowing that international capital will find them. So, for example, Saudi Aramco, it's predicted to be the biggest IPO ever, is listing on Saudi's exchange, which did not really exist until a few years ago, and also potential listing in Tokyo. Notice that New York is not mentioned anywhere here. Basically, this would not have been possible even a decade ago. All this means is that political turmoil in local markets can have significant and immediate impact globally and within the US. Hong Kong protests might be isolated to Hong Kong and Brexit is isolated to England, but these events have the potential to rock the entire world by directly impacting international companies that are listed in those markets. Even if US continues to adopt protectionist policies, it will just not be able to fully protect itself against these events. Not as long as US companies need international capital and are willing to go abroad to get listed.
Yeah, absolutely. I want to go back to you, Bernhard. So we talked a lot about politics and uncertainty so far, but obviously that's only one element among many when doing cross-border M&A in the tech space. So I'd be curious to get your views on what do you think the most key important considerations are when advising on cross-border tech deals. What are you putting at the top of the list, and why would you put those issues at the top of the list? And before you answer, just a little heads up for the audience, we agreed that we're going to skip tax today, even though obviously tax is super important, but for the focus of this presentation, we're going to focus on other things. So Bernhard, over to you.
So from my point of view, one very important consideration is local law requirements. Of course, all cross-border deals need to reflect any mandatory local law requirements that exist. This is particularly important in the regulated field, for example, when it comes to banking or insurance. We as a company or law firm, we're often engaged in deals in this area where there are regulatory requirements in each and every country, and of course this is even a bigger issue in Europe, where you have 28 different countries with 28 different laws and maybe 28 different requirements. So safeguarding that these local law requirements are indeed adhered to, and that this does not cause any problems to the deal is a very important thing. The second point that has very recently arisen is data protection. So as you all may know, in May 2018, the General Data Protection Regulation in the EU entered into force, which brought for the first time a harmonized framework for data protection throughout the whole EU, which has clarified the laws to some extent, and of course made it also easier working on cross-border transactions, because the law is now more or less everywhere the same. Nevertheless, the GDPR also brought with it extremely high fines, which are now calculated as a percentage from the turnover of the company or even the group of companies, which is a drastic change. Prior to the GDPR, in Austria we had fines of maybe a couple of hundred or a couple of thousand euros, and now in the most recent decision, the Austrian Data Protection Authority imposed a fine of 18 million. So there is indeed a drastic change, and even though GDPR makes it easier to some extent, it has also raised the stakes quite dramatically. Third thing is just that it's important just following the trends in tech. You always have to stay on top of the game, of course, and need to follow those trends to be able to advise in such transactions.
Yeah, absolutely. And you make a great set of points there, particularly around data, which we're going to be coming back to a little later in this webinar. Christina, any points from you to follow up on that before we move on?
Sure. Well, in general, we do most of our M&A work in-house. We have a team that has a lot of M&A experience and a lot of cross-border work as well. So we believe doing the work in-house gives our attorneys opportunity to learn and take those experiences to the next deal. However, this approach is not always possible. As just mentioned, local regulations or the political situation on the ground might really make it necessary for you to use local counsel. For example, if you're working in the Middle East, most likely you would need local counsel who can work within Sharia law, which impact all transactions that have any sort of financing component, which I think would include pretty much every M&A tech deal. If you're working in certain countries that have potentially dangerous political instability, you will also need to hire local counsel to perform due diligence and to hold on-the-ground meetings. If you do send your own people, you need to consider hiring security personnel and prepare your people that the movements will be severely restricted. For example, we had to do that when we worked in Nigeria and Egypt during particularly turbulent times. Finally, don't forget language barriers. I think that's really important. Everyone assumes that English is the main language, especially for international tech companies who are looking to do work with U.S. domestic companies. The main documents might be in English, but most of the operating documents are likely to be in the local language. Also, mid-level managers who hold most of the operating knowledge are likely to have limited English skills. In these situations, I think it's important to have local counsel and to carefully review the skill set that your team has and what you are actually missing given the situation on the ground.
Thank you so much, Christina. So, Stacey, I'd like to come back to you now. So we've been talking about these considerations and concerns when doing cross-border deals. And when we think about tech in particular, what I'm seeing, and I'm sure you're all seeing too, is this rapidly growing discussion in many countries, particularly here in the US, around the impact of tech on people's lives. And people use the phrase techlash sometimes to describe this sort of phenomenon where consumers are becoming increasingly suspicious around how their data is used, around the consolidation of power in a handful of big tech firms, high-profile cyber breaches and that sort of thing. What's your view on how one navigates these sorts of environments, given everything that's going on right now?
Sure. Yeah, as I alluded to before, right now every move of a tech firm is scrutinized, and we can't really go about and make deals as though business as usual is happening around tech firms. It seems like every week an employee of Amazon or Facebook is testifying before Congress. The antitrust agencies in the U.S. have announced major antitrust investigations into the main tech platforms. European regulators have fined Google billions for 3 separate antitrust violations, and presidential candidates are pounding the drum of the danger of too much data in the hands of a single firm. So there's increasing vitriol from consumers as well, who are concerned about how their data is collected and how it is used. So what does that mean when you're trying to do a tech deal? It means any deal involving tech, again, using the broad definition, is going to get scrutiny from competition law regulators. But how that increased scrutiny is going to play out isn't entirely clear yet. So the name of the game is uncertainty. Some jurisdictions have called for the development of a special task force or a unit within an existing regulator that is devoted to tech issues, including deals within antitrust agencies. Others have called for the development of a new agency altogether. Some agencies have discussed applying different principles to the analysis of deals that involve tech companies. There's convergence among the regulators that tech should get more attention, but there's not convergence among the regulators worldwide on how to evaluate tech deals. So what we're also seeing is a bit of a competition among the regulators to see who's going to be the first mover to get out the platform guidelines or policies on evaluating tech mergers. All this does is actually sort of create a layer of uncertainty that you have to plan for, and often that uncertainty comes in the form of delays as the regulators decide how they're going to work together and what they're going to ask of the merging firms. Second, as I evoked to earlier, the more traditional antitrust standards we are seeing used in merger evaluation may be softened in tech mergers to take account for concerns that perhaps can't be quantified in economic terms. Bringing us back to the issue of consumer data and privacy, under traditional antitrust analysis, a regulator might not focus on whether a combined firm's access to two sets of customer data might somehow allow the merged entity to more easily invade or take advantage of a consumer's privacy concerns. Typically, instead, you're looking at whether the merger will increase price or reduce innovation or reduce customer choice. But this is an issue now that regulators feel they need to look at because consumers are concerned and it isn't necessarily clear how else it's going to be considered. And this is particularly acute in Europe, where we've seen some regulators already take into account consumer privacy issues in merger analysis. And some jurisdictions that have a broader standard for evaluating mergers based on a broader public interest set of criteria, South Africa is one of these, may also start taking into account these privacy issues. So if you have a tech merger, you also have to think about how you're going to respond to regulator concerns about what you do with data. Third, even non-tech or less tech mergers may get caught up in review if they involve issues of innovation or nascent competition. Antitrust regulators right now are very concerned about killer acquisitions, and this derives from a concern about tech company power, but the general principle can apply more broadly. Killer acquisitions are acquisitions by larger firms of small upstart companies, which one day might be a competitive threat. So regulators are therefore very focused on any threat to diminished innovation or acquisition of new entrants, because any policy changes, even if motivated at big tech, theoretically are going to be applied consistently across industries. And finally, you also need to think about if your company amasses data in any way, whether the regulator may think of data as a source of market power. Typically, you look at revenues as a source of market power. That's certainly not the only way to do it, but if we're being crude, that's more often what a regulator goes to. But if you're combining two companies that hold a significant set of data, the regulators are going to look at whether their control over the combined set of data is going to make it harder for other tech firms to enter or to continue to service their customer because now they don't have access to that additional set of data.
Thanks so much, Stacey. Yeah, indeed, I think what we're seeing already, and I think we'll see as this webinar continues, is the critical importance that data is having on deal making and the landscape for that. Christina, what about you? I mean, you spoke a few minutes ago about some of the cultural differences and jurisdictional differences. As you think about these issues, are there any other considerations you think that are relevant here?
Absolutely. I would say that I think cultural differences and different approaches to M&A often are underestimated, and they, I think, have a significant power to derail any transaction or kill the project post-closing. As we know, most M&A deals fail post-closing, so I think cultural differences should be front and center when starting a new transaction. And let's say, for example, you start to conduct property diligence for an M&A deal and discover various non-compliance issues with data privacy. The key question, I believe, is to ask not how do I fix these issues and move on. I think the key question should always be, how did these issues happen in the first place, and does the company have the culture to change its behavior? If the answer is not, then you have a much bigger problem, and it might kill the deal. I would argue that it actually probably should kill the deal. Same analysis could be used with respect to OFAC, FCPA, money laundering violations, whatever other regulation of the day that everyone's concerned about. Technically speaking, of course, when you acquire a company or starting a JV, you might not necessarily be taking on the pre-closing obligations, but if the culture of the company is such that that it's not likely to shift post-closing, then you will likely encounter similar issues post-closing, and you need to be aware of that. I think culture can also have a serious impact during deal negotiations itself. countries can have dramatically different expectations when it comes to deal terms. For example, there are vast differences in how U.S. and Germany M&A deals approach purchase price adjustments. That's one of the key terms, of course. And it's standard in the U.S., but not very common in Germany. And I think most U.S. companies are surprised to learn they cannot rely on this protection and must buy the company as is in Germany. My advice, therefore, is to have, obviously, a term sheet that's really detailed and to have a final term sheet produced as early in the process as possible. But I would also suggest having a post-closing term sheet. So this way, both parties know exactly what the expectations are. And you can also help identify issues that might necessitate either a change in the deal terms or potentially for parties to walk away.
Thanks so much, Christina. Bernhard, I'd like to switch over to you now. What's your perspective on this? Now, you spoke a few minutes ago about GDPR, which obviously has been a massive change in the way companies have to do business, not only in Europe, but also all across the world. How has the implementation been so far, and what kind of changes has it led to for deal making?
So there's really two main issues when it comes to GDPR in the framework of M&A transactions. One is the business conduct of the target itself, and the second one is the impact the new data protection rules have on the due diligence process itself. Starting off with the implementation regarding the target's business, it's been quite a bumpy road, to speak quite frankly. Many companies have waited far too long to start with the implementation process. Even large companies have waited far too long, which made it much more complicated since the burden is rises quite exponentially the bigger the companies are. So most companies were not finished by the deadline when the GDPR entered into force, which was the 25th of May 2018. Really, only some really made it. When it entered into force, some at least followed through and implemented it as soon as possible. Some then took a rest as soon as the deadline passed and did not follow up. So still now there's quite some companies that have not implemented it as would be needed, and we also see that quite often in due diligence processes. What this is now, of course, an important part since the potential fines are so high. It is quite rare that a company has really good data protection documentation and internal data protection rules. Second part would be the impact of the GDPR on due diligence processes itself. We now see that companies feel much more uncomfortable releasing data and providing data. Much more often now, data that is provided to us will be aggregated or blackened. And this is, of course, also something that does, in some cases, cause some troubles during the due diligence process, because in order to verify information and so on, you need to be provided with the exact data and not just blackened data. Nevertheless, even though now GDPR is often used as an excuse if someone does not want to provide any data, I think GDPR has nevertheless made the process easier, as we are now have one set of rules over all countries in the EU.
Thanks so much, Bernhard. It's really interesting. I'd like to change topics a little now, and going to Christina, talk a little bit about choice of law and jurisdiction. So for people who do domestic M&A deals, choice of law and jurisdiction is not that complicated a discussion, but for cross-border deals, tech or otherwise, obviously choice of law and jurisdiction is a critical component of the deal planning. What I'd like to get your thoughts on is how does that discussion usually go? What do you think the considerations are? Sometimes things are not considered efficient by one party. Sometimes things are not feasible for another party. What's your view on how that factors into cross-border deal making?
Sure. Well, I'll be honest. My first reaction is always New York law will be great. Let's just do that. But then, for various reasons, as you just mentioned, that's usually not the right choice, actually. For example, if you pick New York law and venue, but if you are working on a transaction that involves significant physical assets, such as factories or land, located in a different jurisdiction, local courts are not likely to respect New York court decisions, even if somehow you convince New York court to hear it. You always need to think about would local courts enforce this judgment. Well, on the other hand, if you think the decision is easy, let's go with local law and venue. Be careful with that choice as well. For example, in India, if you choose local court and law, the Indian courts have much broader authority to interpret the issues in dispute, and the lawsuit might last for years. But if you have a foreign award that you're trying to enforce in India, it will be a much faster process in my experience. This is particularly true if you litigate in one of the countries with which India has a treaty, United Kingdom being one of them. If you are also working in the Middle East, your documents might need to be Sharia law compliant. Some parties think their documents are governed by Sharia law, but that is not the case. Instead, it is common practice that the parties agree to choose English law and as the governing law and the English courts as the venue of choice. However, in order to get the deal to regulatory review locally, you would need to ensure your documents are drafted in a way that would ensure Sharia compliance, even if there's no reference to Sharia law in the document. And I think, these are just a couple of examples, but there's a variety of those situations where you just don't expect the local law to apply, or it applies in a different way than you expect it to. So one option to avoid all these issues is mandatory arbitration and mediation clauses. And I'm really starting to like them because you can choose local law as the governing law, which may give you a leg up in terms of enforcement of the final judgment, but require that the process is conducted in English. This may mean additional costs if you need to translate certain documents, but at least you will be able to oversee the process instead of totally relying on your local counsel. And just keep in mind that some jurisdictions already have well-established procedures, and you should speak with your local counsel to make sure you're not reinventing the wheel. For example, in Singapore, I know the parties would typically expect English law and arbitration, so you might look inexperienced if you come in and suggest New York law and mediation instead. And going back to what we said before, I think each deal is unique. I suggest you carefully consider the local environment before starting the transaction. Once you understand the local restrictions and expectations, decide very early in the process on the governing law and venue. And then you should really structure your whole deal around these two choices, not the way it's typically done where the deal is structured and the venue and the law is chosen. And I think that's where a lot of issues come in.
Yeah, thanks so much, Christina. And I very much agree with the point you made on arbitration, which, in our practice, we often see as a very good solution for cross-border deals where you have parties from different countries and different cultures and different concerns around how a dispute may be litigated in other places. Now, as much as I like New York law, Delaware law, sitting here in New York, I recognize challenges when it comes to implementation. So Bernhard, I wanted to get your thoughts on that. Obviously, you can't just ignore local aspects, local regulation, even though for those of us sitting in New York, that might be tempting sometimes. So even though we see this trend, documentation to some degree is becoming more standardized. Clearly, the document always needs to be, enforceable in the jurisdiction that's relevant. So when we're doing cross-border deals, how is it that you think we should find that balance between standardization of documents and adaptation for local law considerations?
Yes, of course, standardization is, of course, a very good thing, which makes the process much easier. And of course, we're seeing more and more standardization, even here in Europe, making deals much faster and much easier to get through. Nevertheless, of course, you cannot just exclude any local law provisions. There are many, or there may be, depending on the framework, there may be many mandatory local provisions that you need to rely on, and there's as I said, data protection laws that you need to comply with. There's antitrust laws. There's other regulatory laws that you may need to comply with in different areas or sections. And this can quite often also be a deal breaker if the business is run by a potential target is infringing local law, and maybe aspects of local law that are different than the local law in your own country, then this may be something that may even break the deal.
Yeah, absolutely. So I want to come back to data. We've spoken about it quite a lot during this session, and for a good reason. Obviously, it's becoming highly relevant to so much of the work that we all do. So Stacey, coming back to you, we've been talking about global local standards. I'd love to get your thoughts on the challenges around collecting, reviewing, and understanding data scattered across multiple jurisdictions with various data privacy laws governing it all in the context of doing these sorts of deals.
Sure. With the caveat, of course, that I am not a data privacy lawyer, it is still something that we have to think about, all of us, when we do a deal. We have to think about it in due diligence, right? You're collecting data from all over the world, and you have to think about what standards apply. Here, in some ways, I'd say GDPR might have helped because it has harmonized something. You know, before you used to have to go individual jurisdiction to understand the data privacy laws. I think now GDPR provides a standard that, for a lot of people, if you've reached the standard of GDPR, you've probably reached a global standard, and there are a few jurisdictions that would require more. So that's helpful from a due diligence context. A lot of the due diligence materials that may have personal data in it can be dealt with by redactions or otherwise managing the data that goes over to the other side. And that's something that you just need to put in a process in place early, involving your bankers, involving your clean team, and those folks who can really pay attention to what data they're getting and making sure it's appropriately managed and cleansed before it goes across. The other area that, from my perspective, requires quite a bit of data is, again, the antitrust approval process. You get all this data in the due diligence process. That's important, but that's only going to one other party. And when you do for example, second request, where the United States government is going to take a hard look at a deal, it's essentially the largest subpoena you've ever complied with. And you may be producing data from 30, 40, 50 custodians. And if you're in a global deal, those custodians may be living in jurisdictions that are subject to more rigid data privacy laws than they would be subject to in the United States. And so you have to figure out who those custodians are early on and come up with a way to deal with their data to minimize what has to be given to the regulator. It is a little bit difficult. The United States regulators have not always been incredibly receptive to the argument that we can't produce particular documents or data because it's shielded by a privacy law elsewhere. And similarly, some of the other regulators in other jurisdictions have not always been friendly to the argument that we have to give this data over pursuant to a government order or pursuant to a government subpoena. And so what I think you have to do here is have a conversation with the regulators really early on to try to manage it so they're not actually really pushing for some of the data that is subject to greater privacy laws. And if so, if they are going to require data from people who are in some of these jurisdictions, you need to have that conversation with them early before you are putting your productions forward and telling them it doesn't have key components of data because of privacy concerns. At the end of the day, a lot of that also can be managed by redactions because some of the personal information that is protected by these laws really isn't going to be necessary to most merger reviews. So you just have to manage that process, have processes in place with your bankers and your vendors to cleanse for that data before it goes over to the other side.
Yeah, absolutely. And I think as another point of sort of collision of things that are happening now, and we have GDPR, which we've talked about, and obviously has been a massive change. And here in the U.S., obviously in California, the California Consumer Privacy Act, which was brought in recently, is going to have its own very significant impacts. But in the context of this patchwork we have here in the U.S., where various states will have something around this and other states will not, and each one will say something slightly different, and the pressure around trying to standardize that with some people thinking the only way to do that is with federal regulation. But how does that happen going back to our early discussion around politics and everything that's going on in Congress right now? Is it really likely that a federal data law is going to be passed anytime soon? It wouldn't seem to be a priority at this precise moment in time, but it does add to the challenge when it comes to navigating data from different places. Going on to Christina, first of all, could I get your thoughts on data privacy laws and the challenges that you see when it comes to compliance in that regard?
Sure. Well, we are a data company. That's our main asset. Thankfully, we don't sell data, so that helps a lot in terms of compliance. But we are obviously incredibly concerned about this issue, and we'll watch it closely. But one thing I would say is that everyone always assumes, GDPR and CCPA are the gold standard, so you need to take your whole data set and then bring it up to this high standard in order to be compliant. Well, that's not necessarily true. Let's say you have operations, in Brazil, and you have a huge data set there, or you're acquiring a company in Brazil that has a huge data set, and Brazil doesn't have GDPR standards or anything similar to that. Then you don't necessarily need to take that data set and then clean it, because there might be business advantages of keeping that data set in Brazil, never moving it out, and then using that for your operations there. So just keep in mind, it's good to have clean data that meets the highest of standards, but if it's not required and it's not strategically necessary, then there might be other options on the table, at least in the near future. The same thing could be said about US. So California has its own standards, but other states do not. So if you have data sets in certain states that do not have these standards, keep it there for now, especially if there is revenue or a strategic advantage to that. But again, we are very aggressive and we're a data company, so we have quite a lot of experience in doing those kind of strategic projects.
Yeah, makes sense. Bernhard, what's your view on that?
Yeah, I fully agree with everything that has been said, and I really related to you when you said it's complicated in the US because every state has its own legislation. We in Austria were in a quite difficult position before GDPR entered into force, because we had one of the strictest legislations throughout Europe, even sometimes hindering a business-oriented approach, and sometimes businesses couldn't do things in Austria that they were doing elsewhere in the EU quite easily. So the GDPR definitely brought some relief in this respect, even though, of course, the fines that are now imposed are much higher than they were before. But it was definitely also an opportunity, for example, for Austrian businesses to make business in areas where it wasn't possible before.
Yeah, absolutely. So as we move towards the end now, I want to switch gears and talk about one of the most important things that happens in a deal, which is what happens after it closes. Those of us on the external counsel side, like us at Clifford Chance, we obviously spend a lot of time doing the deal, and then when the deal is closed, we are not part of that post-closing process very often. So I'd love to get views from Stacey in terms of integration. The deal is now closed, and you've got this new business to integrate. What's your experience on that? What works? What doesn't work? What are some of the stories or challenges or issues that you've come up with in that regard?
Sure. First, you have to start preparing for integration planning, I think, before you sign the transaction. From an antitrust perspective, the period from sign to clearance or sign to close is fraught with risk, because premature coordination between the companies and premature exercise by the buyer of control over the seller can bring gun-jumping liability. And aside from there being liability, even if you end up not necessarily having a violation, if the regulator smells that there might be something going on, they're going to look into that, and that's going to delay the close of your deal, which isn't good for anybody. But this is an issue because, understandably, the buyer wants to start as soon as they can get to the business. They're buying an order, and that target, the employees of the target are already thinking about their new boss. So incentives really change in this time period, and it's human nature here that you have to manage. I'd say the primary thing you need to do is start on day one after signing and train on gun jumping and continue to monitor and follow up. I think that a lot of times people start very good, very strong on messaging on gun jumping and managing that integration. But after about a month or two, everything's set up, people are doing their jobs, and you forget to check in. And as you get closer and closer to potential closure, people sort of let their guards down when it comes to gun jumping. I also think you need to follow up with those folks you have trained after you receive regulatory clearances, because if the deal doesn't close, you still actually could have issues under the gun jumping regulations and laws. So you need to make sure that people know maybe one clearance in this jurisdiction doesn't mean it's okay to go ahead and start following the orders of the buyer or sharing certain information. I think you need to set up processes from day one. Again, you really can leverage your bankers here to put in place clean teams, identify information that should go through a clean team process versus more generally, and have point people who are assigned to do this. Typically, from an antitrust perspective, we have the team that is charged with getting the deal cleared, and we have a separate lawyer on big deals where a lot of integration planning is occurring, whose sole job is managing integration and those gun jumping questions to make sure it gets the resources they deserve. I also think it is really important you talk to your other party, whether you're buy side or sell side, about how to go about this sign to close period and make sure you're sending similar messages to your employees. And the minute issues arise, and they do arise in even the cleanest of deals, it's important for the parties to get on their phones, talk to each other, and figure out what happened and make sure that everybody is instructed on how to go forward. I'd say it's also finally very important to have local counsel involved in integration planning and any gun jumping trainings. Certain jurisdictions actually have different rules about gun jumping. We're starting to see some jurisdictions who haven't been involved in this area start to enforce in a different way, and the enforcement standards may be different. For example, we've seen a lot of enforcement activity out of Brazil. So it's important that your local counsel is involved, or if the clearance hasn't been obtained in a particular jurisdiction, you're thinking about whether something different may apply there vis-a-vis gun jumping. And so I think local counsel is critical to make sure you're compliant with local rules and help police local conduct.
Stacey, that was a fantastic explanation and much appreciated. I saw a question that just came in from someone on the webinar, which is they were not familiar with the term gun jumping. So maybe I can ask you as the antitrust lawyer on the webinar to explain it more clearly than I could.
So it's a very colloquial phrase that's used to describe the idea that two parties who are in the process of merging in the sign to close period already start acting as though they are one party. And antitrust regulators don't like this for a couple reasons. One, they want the opportunity, if the deal is going to be notified before them, they want the opportunity to review the deal and opine on whether the deal is acceptable, and if not, order remedies before the parties actually consummate that merger. So that's one reason. They don't want to be deprived of their ability and their right, really, to review the deal. Two is they're worried that if the companies, this really applies more if the companies compete in any way, if the companies sort of start exchanging information or coordinating or saying, hey, I know this customer issued a bid to both of us, but we're about to be the same company, so I won't bid to this one, so you guys will get it. Next time we can do the same because we're, one day we'll be the same company. Well, in the event the merger is blocked, you've harmed the competitive process between the companies, right? And it's hard for the companies to go back to where they were because they've exchanged this information and started coordinating their behavior in a way two independent companies shouldn't be allowed to do. So we want to try and prevent both those things, and when you sort of start integrating your merger too quickly and actually acting as though you're a merged firm before you've gotten regulatory approval and closed the deal, that's what's called gun jumping.
Thank you so much, Stacey. That was a fantastic explanation. Before we wrap up our discussion, I wanted just to turn over back to Christina first and then to Bernhard. Are there any other final points that you want to make to our audience around these issues?
Well, I just want to say I definitely want to reinforce everything Stacey just said in terms of setting expectations early and staying organized. I would also suggest, like they seem to have at GE, to have an attorney or at least a paralegal who is responsible for making sure the deal moves forward and the integration happens. So planning ahead, having a checklist, having deadlines that must be met, all these things will help you stay organized. And in terms of using local counsel, like I said, we do most of our work in-house, which is great, but then there could be potential situations where we are in over our heads or we run out of capacity on a particularly big deal transactions. So in those situations, I would say have local counsel, get them on board early. You don't actually have to use them until you absolutely need to. But this way, they're at least familiar with the deal. They know the key terms, the expectations, they know the big items that have come up during the negotiations process. And then you can use them as necessary when you reach your capacity internally. And one thing to know regarding that also is just if you are working on cross-border transactions, usually you're not just in 2 markets. Usually you're 2 or 3 or 4 or 5 markets. And it makes no sense, I think, to use different law firms in each of those markets, because then you have to serve as in-house counsel. You have to be the one overseeing all these law firms. Instead, I would suggest having one big law firm. There's a ton of them out there. Clifford Chance is one, Whiting Case, Latham, whichever. They usually will have a local office in one of these jurisdictions, and the head team that's leading the M&A deal would be able to coordinate on your behalf. So you minimize your own work, your headaches. Just make sure there's really local offices where it's the same partners across all of them, as opposed to regional law firms that may have a contract with the main law firm. Because I think it's just the work product that you get is usually a lot better when it's one law firm helping you with the entire transaction as opposed to regional law firms.
Thanks so much, Christina. Bernhard, I'm going to have you finish our session here. So any further thoughts from your side?
Yes, just a quick point to allow some questions as well. I think it's very important to stress that combining business cultures is a real challenge, where often, which is not, of course, not a legal issue, but this is often one point where deals fail after the merger process has finalized, because particularly the tech industry is such a fast-paced industry, and employees are very highly sought after. So it happens quite often that if cultures clash, that all people run away quite quickly.
Thank you so much, Bernhard. Well, I just want to say thank you so much to everyone. Stacey, Christina, and Bernhard, that was a fantastic discussion. Really appreciated hearing all your thoughts, as I hope everyone else on the webinar did. Before I finish the session, are there any questions or any other points we should cover before we wrap up?
I think we got a question online.
Yes, there is a question. What is the best way to train non-lawyer resources to combine resources and avoid territoriality concerns?
I think that's quite a tricky question. I'm not sure, Stacey, if you figured this out yet. But in general, I definitely think making sure everyone's aware of that this particular resource has been identified as a project lead. And I would strongly suggest picking 1 or 2 individuals who are responsible. If you have a wider group than that, I feel there's a bigger chance that everyone else would think that another person is responsible, or they would be afraid to act. So in my experience, 1 or 2 people who are clearly given authority and who are responsible at the end of the day for making sure the deadlines are met. That seems to be the best way forward. If it's non-legal resource, that's completely fine, but make sure they're working as closely with the legal, at least 1 legal person as possible, because otherwise I feel like, again, there could be potential for miscommunication about whether legal is leading the deal or this individual who's not on the legal team is leading the deal. And in my experience, avoiding miscommunication is the #1 goal of executing a smooth transaction.
Great, thank you very much. I'm sorry, go ahead.
No, as I say, thank you so much, Christina, and I think that concludes the session. So thanks again to everybody for joining. We really appreciate everyone's time.
Very much for the presentation. I hope everyone found today's discussion to be helpful and insightful. You can register for future Bloomberg Law webinars by accessing our store at learning.bloomberglaw.com. You will currently see instructions on how to earn credits for attending today's webinar. Please fill out the webinar evaluation survey. as well as confirm your certificate information. Some jurisdictions may take 4 to 6 weeks to receive credit. You will receive your certificate via email when it is available. If you have any questions about continuing education credits, please email us at credits@bna.com. Finally, I want to again thank our speakers and WSG for sponsoring today's webinar. Thank you very much for participating and enjoy the rest of your day.